5 judges up here are standing between you and the cocktail hours. So anyway, so a number of years ago, Judge Smith came up with this idea that we would take questions from the bar, that the judges would, and we didn't really think anything of it at the time, except we had judges from other states that had appeared at the conference, and they were like in shock and awe that the judges would open themselves up to the bar for whatever questions. Our newest judge just leaned over to me and she said, "I didn't get a list of the questions. What are they?" And we're like, "I have no idea." So let me just very briefly, again, for those that weren't here in the morning, thank a bunch of people, the entire committee. I won't go through it again, but in particular, Jennifer Wood and Josh Xavier, who chaired this and worked full time on it and did just a phenomenal job putting it together. So really thanks to them. And then you really have no idea maybe you do, I'm sure you do actually if you practice in our federal court, what an incredible staff we have. Our clerk's office and our probation department, IT department are just second to none in terms of public servants. They understand the servant part of public servant, and they are there every day figuring out how they can be of service to you and your clients and to the public and to the press and whatnot. So without them, this wouldn't be possible. And in particular, we've got to thank Raina Smith. This was her first district conference. I don't know where Raina is. She's outside. Someone can tell her. There she is, Raina, thank you. She also, yeah, right. So with that, ask away. All right, cocktails. No. Where's Lynette? 2 years ago, it didn't start out very well, so I called on Lynette to start us.
Okay. I'd like to hear from each of you as to one takeaway that you had from the sessions that you had today that was the most significant on. Oh, sorry. What did you find? What? Still, you can hear me now, right?
Yes.
Okay. I'd like to ask each of you just your impression of one thing that happened in today's sessions that you found really the most memorable of the discussions that you heard.
I'll just start real quick because it was I think Ezra Rosenberg referred to himself as the Donald Downer of describing the current conditions of voting rights litigation. My eyes weren't opened to the extent of where voting rights have come to today. And I've heard a lot today. I mean, my God, my head's spinning and ready to burst. But that one in particular kind of, so that's my one takeaway.
I would say there are so many, to reduce it to one, and I'll take that opportunity to say that Judge McConnell deserves a lot of credit for this conference too. And he's not, so he's no doubt the part of the spirit that's behind the committee that put this thing together. So he deserves a real shout out. I'd say listening to Fred Gray and the sort of living history, and I think I ran into Bob Mann in the hallway, and he said, you know, there's 2 or 3 generations coming behind us who aren't going to be able to speak to somebody like Fred Gray or hear him talk. And how do you get the next generation to get that history, because it's just so amazing.
So it's hard to pick one thing. I thought Fred Gray's speech was incredible. What I took away from the qualified immunity conversation was that we can have these conversations, and we have to have these conversations in order to move the ball. We have to be willing to sort of break it and fix it. In order to create something better. And I think that discussion made me realize that it's not a next week solution or a this year solution. It's over the course of the next 25 years that this work needs to be done.
Okay, one thing really hard. I will say that at the end of the lunch sequence of events, I was kind of bowled over by the concept of the arc of great people, and that we had 3 of them, Fred Gray, Olin, our very own Olin, and Bob Mann, and that those 3 people were juxtaposed together as people who had, in different generations, were doing this work. And then you looked around the room, I did in that moment, and saw all these kids, all these law students who were like asking questions that were so brilliant. And I thought, the next generation, they're here. They're here in this room, and this is going to be amazing to watch.
What had the most impact on me was witnessing Mr. Mann get that award today, and then just thinking about what a privilege it's been for me to have interacted with Olin Thompson in the courtroom in the years he appeared before me, and then interacting with Mr. Mann, and just to be on the same plane with them, to dialogue with them about cases and important issues. I didn't realize how important it was to me and how privileged I was to be able to experience that.
Good afternoon. First and foremost, I want to say thank you to all 5 of you. I am somebody who has never practiced in federal court, and yet have had the opportunity to interact meaningfully with each of you. I know you've all been very committed to the university, to the legal community, so thank you. And on that note, as somebody who does not practice in federal court, but would like to, do you have any advice for people who are aspiring to practice in federal court, or any sorts of mentorship or programs, or how would somebody who does not know anything about, navigating the institution kind of go about getting familiar and beginning that part of practice, if you will?
What? You were set up, weren't you, for
How
that one?
funny that you should ask. Well, I was waiting for the question that would tee this up. I'm not sure this is the right question, but here's the reality. We have a pro bono panel, which was adopted in 2014, and it's lawyers from our bar. So you have to be a member of our bar, and you have to have insurance. Those are the only requirements, and you don't have to have any experience at all. And all you do is go, you can actually go to the website. There's a 2-page form that you fill out that says who you are, and then you're on our panel. And we are bombarded, 30%, with pro se cases, litigants who are sitting, they come in and they handwrite these things, prisoner cases, mountains of them. And these cases come to us without counsel, and we really struggle to find someone who might be willing. First of all, we've got to sort of screen them, and we screen them knowing how many people we've got available to appoint. Our panel is getting, very respectfully to panel members, long in the tooth. We need new blood in our panel. So I am actively soliciting anybody out there who is interested in being considered to be appointed on a pro bono basis for a case that's been brought by a pro se litigant. All you have to do, it'll take about 10 minutes, is apply to be on the panel. Then you're on, and when the next case comes down the road, we pull out the panel list. There's one other thing that we try to do with the panel is when we have attorneys who don't have federal court experience, we appoint 2 attorneys, one who does and one who doesn't, on a mentor-mentee basis. You don't have to be in the same law firm, so a lawyer who does not have federal court experience, Jose, keep listening, can be on the panel and get appointed in tandem with someone who does have that experience. So the purpose is to give younger people an opportunity, not just to do these cases, but also to work with a more experienced attorney. So please, anybody who is not already on our panel, think about it, and if you think you can, and all you have to do is you consider the case. Basically, by being on the panel, you're not agreeing you're going to take a case, you're agreeing that you will seriously consider taking a case. If you can't do it because of time constraints, you say no. If you can't do it because you can't stand the client, you actually get an opportunity to meet the client before you decide whether you'll take it. You can say no. If there's a conflict, of course, you say no. So all you're saying by putting yourself on our panel is, we'll consider it. But this is part of where the civil rights case of the future that's going to be game-changing may come in our door as a pro se filing, and if we don't have attorneys who have said on a volunteer basis, I'll take those cases, they may never get legs and may never go anywhere. So please, be on the pro bono panel, and when a case comes down the pike, you'll get contacted by the clerk's office. Here's a case. Will you consider it? You get 2 weeks to think about it. If you want more than 2 weeks, all you have to do is ask for it. If you're having trouble, if you've got somebody who's incarcerated in another state, we'll give you as much time as you need to connect. But let's do it. Sorry, too much time. Okay.
I wondered if you could comment, Judge McConnell, you often say to think outside the box when you're bringing a case, and when you last, when I heard you speak about the utilization of the federal courts, I wonder if you could comment on how cases are surviving, access to justice-wise. I see a lot of 12b6 demises and other ways that cases don't get heard in the federal court. And I'm just wondering what your thoughts might be if you and the judges could share something on that. Because
I'm sure there's statistics that tell you whether there's an increase in 12b6, and I don't know what those are. My gut tells me that there's been an increase in the 11 years I've been on the bench. I'll defer to Judge Smith to go longer back on that if he feels it. I think Iqbal Twombly clearly kicked up the importance of motions to dismiss, but and I don't know if there's a greater degree of them being granted or not, though you may, by your question, may feel like that's the case. But the rules are still the rules, and the standard is still the standard, and we try really hard to apply the rules to the standard, regardless of how it comes before us. But I have noticed a larger number of motions. Is Aileen still in here? Is Aileen? No? She tells me that she's, Aileen, no. She tells me, as my law clerk, that she thinks there's a massive increase in the filings of motions to dismiss. But I don't have the statistics on that, George. I don't know. Have you?
Has Judge McConnell ever granted a motion to dismiss? I'd be
We
interested
follow the rule of law in my
I'd be interested in
chamber.
a statistic on that. I certainly
nice to have
think there
friends.
probably are more filed.
They're videoing this. Do you know that?
Oh, shoot. That was under seal. George, I think we're doing pretty well in terms of, keeping the cases that deserve to be tried moving along and going to trial. I don't know. I suppose you all could answer that question maybe better than we could.
I'll take it to the next one, George, in summary judgments. The last district conference, we had a professor from the Midwest who's Sonja Thomas, I think her name was. And she posited at the last district conference that she thought that summary judgment motions were unconstitutional in violation of the 7th Amendment. So
can we get her back?
We can. You get her back. Professor.
No.
There you go.
Is it on? Thank you. This is a follow-up to the question about how lawyers who do not have federal court experience but are interested in practicing in federal court could get some training, some exposure to federal court procedures. And I thought that might be a good time to let everybody know who doesn't know already about the Litigation Academy.
Yeah, so there is a program coming up. I don't know how well subscribed it is yet, but I think it's scheduled for December, maybe the second week of December, second or third, I can't remember. But that's another one of our Litigation Academy programs. Those have been really successful, and we're always sold out. I think the practical sort of on the ground, get up on your feet and do it sort of experience has been really valuable. There are a lot of people in this room who've taken multiple courses in the Litigation Academy, and we're going to keep doing it. But I think between that and the pro bono panel and refreshing the CJA panel from time to time, which is another thing that we're trying to do on the criminal side, these are the things that we can do. We can't. I suppose there's something else that we could do, which is, and it's been done in other districts. We have not, I don't think so, seriously discussed it. But if you have a motion that's pending, and you want to guarantee that an associate will argue it, not a partner, just using an example. An attorney with under 5 years of experience, let's say, will give you an oral argument. We haven't said we'd do that here, but they're doing that in some places, and that might be something that we could consider. It would be an investment of time on our part, obviously, because we don't do oral arguments in all cases, so it's something we would have to discuss as a group. But that's one way we could give people more on-the-ground experience, I think.
Hello? Good afternoon.
Hi.
Some of you in the room may know, or on the panel may know, the Rhode Island Bar Association has been really... the Rhode Island Bar Association has really been talking about increasing diversity, equity, and inclusion in the courtrooms for members of the public and in law firms and where we work. Of course, there are some sticking points. For example, I'm not sure if we know the demographics of the makeup of all lawyers in Rhode Island, and that can be a challenge. My question to you is, what can the bar do from your perspective to increase racial justice for attorneys and for members of the public? Are there gaps that you're seeing?
Mary, you want to start that one? I told you it was coming.
And lawyers come from Litigation Academy, and I get what they do to solve racial inequality. That's a big one. I don't know that there are any really good answers to that. I do think it's important that we're inclusive, and I wanted to follow up on the last question and say, watch on Zoom. We're still on Zoom, so you can watch a hearing on Zoom. For people who practice across disciplines, bring in somebody who's not in your practice, who's a young lawyer out of law school, somebody who maybe doesn't have the same opportunities, and let them work with you on cases. I came up through a public defender system, and we always sort of sat second chair on cases, and it afforded opportunities for attorneys, more attorneys, to be in court and trying cases. And I think that the private bar could do that. It's an expenditure of money, time, because time is money. But I think that's a way to be more inclusive. I think that we need to bring people to Rhode Island, or keep people in Rhode Island who graduate from law school, and I think that's, good jobs. I'll make a pitch for the law students. Come be law clerks in federal court, So I think that we as a community need to think sort of creatively and again, long term. We need to establish a community of lawyers that are going to be there for each other. That was Bob Mann. Bob Mann was the guy in the courthouse you could ask a question to. You didn't have to be a defense attorney. You didn't have to know him. You could catch him in the hallway, and he would answer any question you had if he could. And he would certainly give you his time. So everybody maybe take that from Bob's playbook, reach out across gender lines, reach out across racial lines, and grab somebody else's hand and pull them along.
Matt?
So, not intentionally to follow up on something you just mentioned, but Zoom. I'm wondering kind of what's the state of affairs with Zoom. I think it's been great to be able to watch hearings and trials from my desk. It's been great to be able to do, Rule 16 conferences and discovery squabbles, mediations. And I think Judge McConnell, you may remember we had a federal bench bar thing a year ago, and my memory is that there was some leave granted to the district courts to conduct certain proceedings over Zoom, and maybe it was temporary. I'm just wondering, whether you all can update us on whether we can continue to expect to have certain hearings over Zoom, and or if that's going to come to an end. I'm a fan.
Great. So am I.
Me too.
Let me give you an overview, and then each judge can speak specific, because a lot of it can be individual to the judge. So Chief Judge Barron, who's the new First Circuit Chief Judge, appointed a whole slew of committees when he became chief a few months ago. And he asked me to chair what he refers to as the post-pandemic committee, where we look at best practices, both what we can do, what the law, what the regulations, whatever, will allow us to do going forward, and then what best practices are for how to use it. So you have to separate it into two things, because you really talked about two different things. One is the court's continued use of remote hearings in toto. That is, the entire hearing is remote, like we've had during the pandemic. And that each judge will speak to, and there's going to be constraints when the emergency declaration goes away and whatnot. The second issue that you referred to isn't one that many people think of, and I'm very proud of our clerk's office that came up with this, that we've been doing, which is now that we're back in court, we have decided that public transparency and availability to the public to watch our proceedings was an important enough value that every one of our in-court proceedings is now set out on Zoom. So you talked about the ability to watch, and I think someone responded to Professor Koukas on that's one way to kind of gain experience. It is unclear how, it's unclear under what authority that can be done going forward. Okay, because you know that there's an there's a judicial conference in the United States regulation prohibiting broadcasting. So our committee's looking at how we get around that. So on a broader level, I think on the broadcasting of in-court proceedings, we're working on it. And I think you have a bench that's very supportive of us continuing that. On the individual hearings that will be held remotely, a lot's going to depend on what we can and can't do, right? So those are practice in criminal law. No, I think it's Rule 53 is the prohibition on everything except initial appearance and arraignment. It has to be done live, period. There's no exception to Rule 53. So in criminal law, when the emergency authorization goes away, we're going to lose the ability to do sentencings or change of pleas remotely, unless they change the rule. And on the civil side, again, the committee's trying to figure out what can and can't be done, but ultimately it's going to come down, I think, to discretion of the judge, who hopefully will have best practice thinking about it. So my just particular rule right now is on the criminal side, I default to in-person change of plea and sentencings unless the defendant asks or wants otherwise, in which case I'd most likely grant it. In the civil side, I'm still doing most civil hearings by Zoom, basically because I haven't thought about it otherwise. I mean, I haven't thought to change that process, and no one's asked me to change it yet. So I don't know where I'm going to land on which cases get done. I mean, I was telling someone earlier, I was a little disappointed. I had a subrogation case, insurance company against insurance company, involving a product liability case the other day. And there were two local lawyers. but there was a lawyer from Philadelphia and a lawyer from Chicago that argued it. And I thought to myself, you know, if I had done that in person, I'm guessing that our Rhode Island lawyers would have been the ones arguing that. And maybe that's a good thing. So it did open my eyes to that there's a lot of issues to consider on it.
I'll be really brief. I think going forward, Rule 16 conferences, discovery conferences, conferences before, or to get permission essentially to file motions for summary judgment, anything procedural like that on the civil side will continue to be done by Zoom. Substantive arguments on motions will likely be in person, with the exception perhaps for really large, complex cases where you have lots of counsel from out of state. It might make sense to do those by Zoom. On the criminal side, pretty much the same as Judge McConnell. I really want in person for pleas and sentencings. So that's kind of where I am. But I think it's here to stay for all the procedural, pre-trial procedural kinds of smaller kinds of issues.
So my experience has been almost exclusively during the pandemic as a judge, so I know no other world. But I think Zoom's really important for a bunch of reasons, and I use Zoom as the generic, but it allows young lawyers, like I said, to watch. I remember being a young lawyer and having to walk to Superior Court, and inevitably, as you got there, the judge would take a break. And so your half hour that you had to watch something in court got eaten up by the recess. So I think for accessibility, open courts, I hope that our committee in the First Circuit will conclude that we can stream things, because it's not the same as broadcasting, but I don't know. I really want to sort of I think the lawyers should just, not to say decide, but I think they should lead the way on this. I agree in criminal cases, I really feel like changes of plea especially, and sentencing should be in person. But I think that it's the right of the litigants, and we should sort of follow your lead.
Okay, we're changing buildings. So one reality is that the Pastore's ability to throw an in-person hearing out to the community on Zoom is not there. So we can't do a so-called hybrid approach or make things available in the way that you were just hearing about. The courthouse has that technology, we don't. So let me talk a little bit about what I do. The real question is, what's the default? Because I'm going to notice the hearing based on what my default is. And I have very simple rules for what the default is, which I'll tell you in a moment. If the litigants believe that they want it to be other than my default, well, in a criminal case, I don't care what the government wants, but if the defendant wants it to be done by Zoom, particularly if it's clear that the individual defendant, after advice of counsel, that's what he really wants, that's what we'll do. And on the civil side, if the parties, and I've actually not had this happen, if the parties agree that they'd like to come in person, and I've noticed it as a Zoom, I'm fine with that, with one exception, which is mediations, and I'll go through that. So let me tell you my defaults. Criminal, all in person. Ironically, there are the two categories of criminal proceedings that are allowed to be remote, notwithstanding the CARES Act. Initial appearances and arraignments, I think, are very important to be done in person. It's often the person's first contact with the judicial system, and I always notice those as being done in person. My sort of moving down the continuum, Hope Court, which is criminal defendants, it's essentially court hearings on a supervision basis, are every other hearing. One's remote, one's Zoom. One's remote, one's in person. And we're kind of experimenting with how that's working. I'm not sure. On the civil side, my default is that everything is remote unless it's going to be testimonial. If it's testimonial, the default's going to be that it's in person. I want to be really thoughtful about leveling the playing field and reducing the costs for the parties. And that's part of why the default is it's going to be noticed by Zoom, but if you'd like it to be in person, I'm happy to switch. And I haven't had anybody ask yet. And then last thing on the continuum is mediations. I am doing all mediations by Zoom, and that I actually feel strongly is the right way to do them. The efficiencies are huge. I'm not seeing any downside. It took a while, but practically everybody in the world now knows how to do this and knows how to be effective to present themselves via that technology so that they can communicate directly with the judge. I don't see any loss of effectiveness, and there's a huge increase in efficiency, and the playing field is leveled, and insurance adjusters who want to be on the phone and barely available, no, they got to be sitting in their Zoom boxes, and they're just as present as everybody else participating, which I think is really, really important. So if somebody asks me, oh, I want to do my mediation in person, I might say no. I'm not sure. No one's asked.
I don't have anything to add on the practice because I think I'm fairly consistent with everybody else. But the one thing I think we should not lose sight of and keep in mind is I'm all about efficiency, maybe too much. But doing a lot of our proceedings on Zoom, I think, increases efficiency and I assume is economically helpful to clients and attorneys, but I guess we should think about at what cost. If everybody just stays in their offices, if you're a 15 or 20-year veteran attorney who's been through the wars, you can sit in your office and bang out a lot of things. You've already established yourself in a practice and you're competent. I fear it's going to affect the community of the bar. I fear it's going to affect the life of the courthouse if nobody's coming into the courthouse. And I fear it's going to negatively impact young lawyers who are sitting in offices just remotely watching things and never directly interacting with lawyers, clients, and judges and court personnel to gain those relationships and that experience. So I think I'm on the same page with everybody else, but I think we ought to think about the long-term cost of that to the practice.
Right here, Heather. Oh, I'm sorry.
Hi.
Okay,
For my fellow law students and I would love to hear your thoughts on strategies for effective oral advocacy, whether it be, as we're entering this hybrid world, best strategies for, especially in motion arguments where there's like a time limit and things of that nature, the best, strategies, demeanor, if that's changed for you over Zoom, et cetera.
Link, you want to take the lead?
Sure. I think everybody who appears before me does a great job with oral advocacy. I don't have any concerns about that, and it's generally helpful. I think the people who do the best in oral advocacy are the ones who have really good, quick answers to hard questions, because that tells me they've thought about what somebody might ask them, whether the judge or what their opponent might say, and they have the answer ready and they've practiced it. Because it's easy to just summarize what's in your brief and go through and repeat that and maybe in a better way or a more robust way, and that's helpful. But the people who can answer my questions like a tennis shot right back at me with detail and confidence, then they make me think like, well, maybe I'm wrong and their point is right. I really got to think about this, because she was so confident when she said that maybe she knows better than I do. But if you're not prepared for the hard questions and then you fumble, it just makes me think, well, then my question is valid because I'm exposing something and you don't really have a good answer to it when you might. So that's my advice.
This is bad because my advice is exactly the same. I think part of the question was, is there a difference between what ends up happening and what's persuasive in person versus via remote technology, via Zoom? I haven't made that observation, and part of what I find is that in the criminal hearings, which I want to be in person, the law happens to agree with me, but I think that's terribly important. It's partly because the criminal defendant is always there, got the right to be there, and the observation of that individual is part of what's going on in the back of mind. So in a civil oral argument, that's just missing. It's just the lawyer's presentation. So I don't find a material difference between the two technologies, well, I guess if we can call in-person technology. And I hate to say that the most important thing that happens during oral argument is how the attorney responds to my questions. First of all, do they respond? If I ask a question and I don't get an answer to that question, I happily go back to my law clerks and say, all right, we now know there's no good answer to that question, so let's write the opinion with that as an assumed reality. So if there was a good answer, it's a real fumble moment in oral argument. And the more that it's a tight, clear, here's the answer to the question, and I really thought it was a question, and now I know there is an answer, that's going to be very powerful. And it's going to really sort of set me back, which is a good thing.
You want me to answer this? So kudos for asking good questions and answering questions all day. I think I agree that the way you answer questions, often in a civil case, you have a hearing exactly because the judge has questions. And so if you haven't thought through, how do I respond to this or how do I respond to that, then you're not prepared to answer those questions. And often, I have a list of questions when I have a hearing, and that's your opportunity. I don't know that there's much of a difference between Zoom and in court, particularly in civil cases for that, but just as a practice tip, we can see all of your facial expressions up close and personal on Zoom. And so look, as somebody who spent years trying to learn to control my face showing my emotions, if you roll your eyes, if you huff, if you like, then we see it. I think it's funny. Other judges might not. But so just
Let me tell you, you guys roll your eyes a lot.
Yeah, you do.
I don't have that problem.
That's it.
Wait a minute, let's just.
Katie had. Well, I don't think I have much to add except that we have a program on that, Litigation Academy. So sign up for it.
I just want to add one thing. I see he raised his hand, so I'm gonna beat him to the punch. But my original mentor as a trial lawyer was Mark Mandel, who I'm proud to say is here today, and I got to work with his son on this conference. He may not remember this, but one of the many things that stuck with me that he taught me in trying a case, and then I'll equate it to arguing, was that you had to find the emotional pull of your case. What was it that's going to grab the jurors, in a viscerally emotional way, and is then going to be your theme throughout the case. Okay, so putting that aside, because hopefully you're not playing to anyone's emotions in a legal oral argument, I often think that figuring out what the value-based legal argument that is central to your argument, and presenting it up front in a way that keeps focused on that, for lack of a better term, emotional pull, that this is what this is about. This is about access to whatever it happens to be, I think is the best way for me to approach it. Because one, it tells me right away what you think is important here, and hopefully you'll convince me. And so that's a bit of advice that I think that can apply there. And the other thing is, and I can only give you this advice for this bench, but this bench reads every brief that you write. And so when you begin a civil argument and you begin recounting the facts to me, I'm honestly sitting there like this, unless I'm in a bad mood, and then I say, don't repeat the facts, and I make you move on. I don't really find that very helpful. I find it really helpful. It's like, right, they say if you want to convince someone, you got to say it 3 times. I like when you start with it, I like when you deal with it in the middle, and I like when you remind me at the end and you end with it. That's, to me, effective advocacy, whether it's a big issue or a small issue, whether it's trying a case or not trying a case. Now I have to call on Mark. Oh, is Katie in the back? Okay, sorry. Katie. Oh.
We have a question here first, I think.
Oh, well, just pause for 1 second, if you don't mind.
Sorry, law students monopolizing the question.
No, that's all right.
I'm curious if your honors have any good procrastination strategies when you're presented with a really difficult decision to make. I think I'm inspired to ask this question by the earlier discussion of judicial courage. I think it was Judge Gardner who said that judicial courage is not like rushing into a burning building, but rather not trying to figure out how to get out of a difficult situation, especially when you've taken an oath to try to do the right
that's
thing.
an incredibly insightful question. Thank you for asking it. There are so many convergent issues that deal with that a judge has to deal with. So we have to deal with the rudimentary rule of law that you don't decide anything that you don't have to decide, right? And you don't reach constitutional issues if you can decide it on less than that. So there's a whole slew of things that we live by in rule of law on how we decide or we don't decide questions. Like, truth be told, if there's an issue that really intrigues me for whatever reason, but it's a constitutional issue and I don't have to reach it, the law tells me I shouldn't reach it. And so I don't mean that as a cop-out on not dealing with the tough issues, because I don't think there's any one of us here that doesn't tackle the tough issues when you're supposed to tackle the tough issues.
Well, procrastination strategies is such an interesting concept. A lot of times we don't even need a strategy. We just, it just like comes so naturally. We don't even have to think about it. There are issues that I would say, one thing I like to do is try to work things out between parties. So I sometimes find that not rushing to decide motions and getting people together for conferences enables me to try to reason with the attorneys. And that's a form of procrastination. I'm not going to rush in and decide your motion. You may think it's an emergency right now, but in a week it won't be an emergency, and we'll have a conference, and I bet by the end of that we'll get it worked out. Or you can file 5 motions in limine, but really you only care about 1 or 2 things, and the other side wasn't going to do anyway, and we can work that out. We almost always do. So I think that's my strategy. Yeah.
Anyone else want to?
I just do something. So many times I see people I've worked with over the years who are faced with a difficult brief to write or some gargantuan project. They don't know where to start, so they don't start. So just do something. Even if what you start doing gets scrapped because you shift gears, at least you're doing something and it gets the momentum towards doing something. So I hope there's none of the lawyers here. I was kind of a jerk to some lawyers in a discovery dispute conference the other day, and I kept saying, do something, do something. Like, just start, do something. But I think that's a good strategy.
Why don't we go to Katie and then Mark?
So I am thankfully one of the younger attorneys who has seen at least a few years pre-COVID, experiencing being in the courthouse, being in front of, the judges and getting to know the clerks in person and really seeing the operation of the courthouse and, juxtaposing it with now in COVID, post-pandemic, whatever you want to call it, I think Zoom is here to stay. At least I hope, from my perspective, it's here to stay. But at the same time, there's a very selfish part of me that wants to get back in the courthouse. So assuming Zoom is here to stay, has the court thought about a mechanism or something, and I don't expect an answer necessarily today, but is there some way to get especially young attorneys back in the courthouse, maybe not for hearings or for trials or for motion practice, but for some purpose to actually get to experience, the courthouse, getting to know the people who make the federal court run, and getting to know the other practitioners in the bar?
I don't know that we have any strategy. If we do, I don't have one. But one of the differences between state and federal court is the lack of a coffee shop. I know it sounds stupid, but in the Superior Court, you sit there and have coffee, you meet other lawyers, you read your discovery, whatever, you write your brief, and there are other people around that you get to know. And I feel like we miss that in federal court. I've been wanting to say, let's have coffee hour like once a month on a Monday or a Friday or a Tuesday, whatever, where we bring in coffee and donuts and lawyers can just come have, we don't meet each other's clerks unless we actually make an effort to do that. So that's my 2 cents.
I don't have
Well, no, hold on, Mark. Sorry, Barbara. Sorry. We're going to go here. I'm picking you over Barbara Hurst here because... It makes me nervous. Yeah.
That's what the Chief Judge says.
Sorry, Barbara. We actually took the bar together, Judge.
Did you really? Yes.
Barbara. I'm going to end with a question, but I just want to thank you so much for doing this today. So in my 48 years of practice, the greatest problems I've seen are racism, not by judges. I just mean racism in our society and inequality. Just what Fred Gray said. So the consciousness that you guys allowed to come to this community of lawyers today is profound. Absolutely profound. I don't mean to take away from a discussion on how to, because that's critically important too in day-to-day life. But the subject, and someone just mentioned Judge Gardner talking about courageous judges, and Fred Gray mentioned Judge Johnson, Professor Malveaux mentioned Judge Johnson, Judge Gardner mentioned Judge Johnson, and I'm wondering if half the people in the room even know who Frank Johnson was. As fine a federal judge ever. So what I would ask, my question is, so many times I've been involved in things and maybe not as brilliant as today, all right, as an exercise, but then it's done. And the consciousness and community you brought to our bar today, I would ask you if there's any way to somehow do what Fred Gray said, as he was told by John Lewis. Keep it going, set the record straight. So my question is, I'm praying that there's some way to keep this dialogue going. And I will do anything I can do to help you, but if there is, please give some consideration to it. And my ultimate compliments to you, I don't deserve your compliment, but my ultimate compliment to you is that you did this today. Thank you.
Thanks, Mark. Everyone else has pushed a book, so I didn't write it, but I'll push it. Mark actually, when I was a young lawyer, gave it to me to read and said, read this. I don't think he said if you ever be a judge like Judge Johnson. But Robert Kennedy Jr. wrote, before he went crazy, he wrote a book. He had clerked for Judge Johnson, who is probably the greatest civil rights attorney of all time. I think actually Mark's brother, Howard, clerked Clerk for him? Yeah, clerk for Judge Johnson. But if you want to read a book about the times of what it was like to be a formerly conservative white male that put on the black robe and swore an oath to the Constitution and took the courage and didn't procrastinate, Frank Johnson is that man. I mean, we have our own Ray Patine to look to as well, who showed courage. But Frank Johnson, biography by Robert Kennedy Jr. is worth the read. Now, Bob.
Practicing for 48 years. Which is true, but...
Sounds a little like ageism there to me, Ms. Hurst.
Well, given that I've been practicing for 48 years, I know closing remarks when I hear them, and I think that Mark made them. So, unless, I mean, if you want to extend this session, then...
No, actually, Nora just called time, so we're willing to take you up on that.
Okay.
What, Heather?
There's a question in the middle that's been waiting for a minute. Hi.
Oh, we began and end with Lynette.
Yeah, and am I on?
Yeah.
Okay, and on, not on? What do I have to push? I'll just talk loud, how's that?
Sure.
There we go, okay. Mark was profound, I will not be profound, I will be kind of nuts and bolts. One of the things that you all are talking about with the Zoom and watching the attorneys, facial expressions, was not necessarily a big fan of the First Circuit argument, but there is something to be said for turning off the screen and turning off the volume of the person who's not making the argument. I just want to tell it to you from the practitioner's perspective. Zoom is exhausting. You're looking at everybody's face at all times. You're always on. And if you're not arguing, I mean, if I'm sitting at counsel table and the other attorney is at the podium arguing, I can't see their face at all in the courtroom. You do. And hopefully I have the brains not to be rolling my eyes from where I am, but I can at least look down. And maybe to think about experimenting a bit, if you're doing a structured argument as opposed to a discovery conference or mediation where everybody's talking, you've got to have everybody on. But to sometimes turn off the picture and the voice of the person who's not doing the argument, give them a break, and also not let them try to telegraph to you just how crappy the other person's argument is, and try a few other modalities with that. It might give some less stress to those of us who are presenting the argument. You as judges, you're always on, and that's the job you took. So I can't do anything for you there. But Zoom has, I mean, that up close and personal is really different. It's a very different experience, and it can be extraordinarily stressful and demanding to always have your face right up there with everybody else. So that's what I want to leave with you. But I join Mark's comments. So what he said.
I hadn't thought of it. That's a great
that.
great thing to think about.
I always do that. Everybody who's not speaking shuts their camera, and I don't know if I did.
She means even the people that aren't speaking at the moment.
Oh, you
I
mean
think,
even at the moment?
Right, right. She wants to be able to take a break
I
if
mean,
she's the opponent.
You've got two attorneys,
me.
three attorneys.
Yeah.
One is talking.
that a
They
trifle,
come up,
wouldn't it?
normally in the courtroom, they come up to the podium, and the others are sitting there taking notes, and then you call the other one up to just shut their cameras off, shut their voice off, and focus on the one who's speaking. That's what they do in the First Circuit when they do the remote argument. Only the person who's arguing and the judges can be seen.
Oh, that makes sense.
Yeah, we'll make that a
I'll
try.
do that from
Let me
now
just
on.
end with one other little plug. The judges just approved that the court is going to adopt an advisory council made up of some number of people, maybe it's 15 or 20, members of the bar from all walks of life, so to speak, and the various bars that we have and whatnot, in order to serve as kind of the organizing group toward input to the court, so that actually we can have an ongoing discussion like this where input can come back on. It'll assume the local rules committee, the district conference committee, the bar fund committee, the education committee, into a cohesive group. Once we finalize it, which should be soon, we're going to put out a notice asking for people to nominate themselves, that are willing to serve. So I'd ask you to think about it, serve, be involved, give us a little bit of your time. We hope to meet like every other month, where both we can hear you and you can hear us, and take it back to the bar. So I'll put a little plug for the advisory council in when it comes out.